And before we begin, I should just remind everybody that there is an anonymity order in this case, that no one shall publish or reveal the name or address of the child who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the child or any member of her family in connection with these proceedings. Thank you. Yes, Mrs. Scott.
Lady, my lords, I've been deputed to lead on behalf of the appellant father in this matter because the principal issue more directly concerns or relates to him. And that principal issue is whether the threshold test for a Scottish permanence order under the Adoption and Children Scotland Act 2007 can be met by concerns which are not founded on facts that have been proven, because the Lord Ordinary in our submission appears to have proceeded on that basis, and the Second Division has sustained his decision. Permission to appeal was granted by an extra division with particular reference to this point, and it is the point upon which the wisdom of the court is sought, and it is therefore the point on which I propose to spend the majority of my time.
Can I ask you, Ms. Scott, I'm not quite sure how applications for permission to appeal are handled procedurally in the Court of Session. Are there grounds of appeal put before the court?
Yes, in terms of the Courts Reform Scotland Act, one's required to present the grounds of appeal and the reasons why this is considered to be an issue of public importance.
And I'm asking partly because the short opinion we have from Lady Peyton identifies one arguable point of law of general public importance, which is the In re J point.
Exactly.
But there are three other points addressed in the written cases.
Yes.
Do I take it that those three other points were the subject of grounds of appeal?
Yes, I think they were rather more shortly stated, but particularly the point about the basis upon which an appellate court should proceed was put before the extra division in the permission hearing.
Would it be possible for us to be provided with a copy of the grounds of appeal?
Of course.
It strikes me there's something of a lack of clarity here as to what exactly the Court of Session has granted permission in respect of.
As it was understood by the appellants, it was permission to appeal generally, but with particular reference to the in re J point, which is recognised to be the most important point in the case.
Yeah. Yes. Thank you.
And I propose simply to reserve myself half an hour to address issues 2, 3 and 4, if my lords are inclined to hear on those issues.
Could I ask a question, again, at the outset, before you develop your submissions, and that is this. Such applications by a local authority for a permanence order with authority to adopt, are they normally applications made in the Sheriff Court, or are they made in both courts?
Both courts have jurisdiction to deal with those under Section 118 of the 2007 Act.
Section 118, yes.
What's the normal practice, though? Is it normally in the Court of Session or normally in the Sheriff Court? Or
It varies, my lady. The Court of Session tends to be a little faster, amazingly, in the light of this case. The Sheriff Courts are under pressure for time. So certain authorities, and certainly West Lothian, have tended to bring their applications in the Court of Session. My learned friend will be able to, Ms Dowdles will be able to develop that. Others tend to focus on the Sheriff Court, but both courts deal with them.
Thank you very much.
And one more, to keep you peppered before you get going. The division which granted leave to appeal was different from the division which took the decision appealed from.
Yes.
Is that usual, or is this something exceptional?
It's difficult to say because there's no established practice. This is fairly new. There was one common member. Lord Malcolm was common to both benches. Yes. And one assumes that was deliberate. But of course, the difficulty is getting the division back. And one of the problems we've encountered is timing here, and that cases like this that need to be dealt with quickly are spending quite a lot of time being delayed in permission applications.
No, we noticed.
I see.
So I can see that would be a factor.
Thank you.
But is it done orally or is it done in writing?
There is an application goes in, there are answers go in, and in this case there was an oral hearing, albeit the appellants volunteered to do it in writing in the hope of getting it more quickly.
But it's very rare for us to have an oral hearing if we're doing it.
Yes, well, every time that I've done it so far has been an oral hearing.
Really?
I presume there will be rules of court. And is there a practice note?
I don't recall a practice note. The main points are made in the Courts Reform Act, but there is a rule of court.
Yes. Well, perhaps at some point simply a reference to the relevant rules would be useful.
We can deal with that.
Thank you.
And one final question. In the equivalent proceedings south of the border, the child is almost invariably separately represented. But I notice that the child is not separately represented in these proceedings. And is the child not represented in permanence order proceedings?
The child is not generally represented. There is usually, if there is authority to adopt, there's a curator ad litem report, but it's simply a report to the court.
Yeah.
It's not referred to in any of the decisions. My lady, we're aware we don't have CAFCAS in Scotland.
I am aware. You have a different system.
We do.
And why is it that in other proceedings involving children one does see a curator appointed, but not in these proceedings?
The curator's role in these sort of proceedings is under the rules of court. Yeah. I think this is probably best explained in Re T Petitioner, which was the original homosexual adoption case in 1996-1997, where Lord Hope examined the role of the curator.
I think we've asked you all the preliminary matters.
Sorry that I haven't questioned yet. And I don't have no...
You will eventually, I'm sure.
I'm sure.
Myself relieved.
Thank you.
What I propose to do, with the court's permission, is to examine the Lord Ordinary's decision, then to look at the Scottish legislation, to look at a comparison with Section 31 of the Children Act 89, which I'm sure my lords are familiar with, and then touch briefly on the cases, which I'm conscious many members of the court have actually participated in. I'm not therefore proposing to read too much back of the court's own decisions. But turning to the Lord Ordinary, my position on the Lord Ordinary's decision is that he has failed to fulfil the essential role of a court of law in deciding where the truth lies and what the legal consequences should be, as distinct from the role of the local authority. And the position is so beautifully encapsulated in Baroness Hale's decision in Re B. I'm simply going to refer to that, and I appreciate it's in volume 2 of the authorities. I'm sure the quotation is familiar. It's in Re B, which is in volume 2, tab 4. And it's paragraph 59, and the manuscript page is 615. And this is what the paragraph says. To allow the courts to make decisions about the allocation of parental responsibility for children on the basis of unproven allegations and unsubstantiated suspicions would be to deny them their essential role in protecting both children and their families from the intervention of the state, however well-intentioned that intervention may be. It is to confuse the role of the local authority in assessing and managing risk, in planning for the child and in deciding what action to initiate, with the role of the court in deciding where the truth lies and what the legal consequences should be. I do not underestimate the difficulty of deciding where the truth lies, but that is what courts are for. Now, that theme is picked up again in later cases, and in particular in SB. And I'm not proposing to go. I'll just give my lady and my lords the reference number. SB is tab 10, and it's paragraphs 18 and 19, but it's to similar effect. And with that, I turn to the Lord Ordinary in the core volume. And his opinion starts on manuscript page 154. where he sets out an introduction to the case. But for my purposes, I propose to take the court directly to his examination of the evidence, which is at paragraph 7 on manuscript page 159. He says, I turn now to consider the evidence, and he explains he's heard the evidence of 6 witnesses and who they are. And at paragraph 10, the general tenor of the evidence adduced on behalf of the petitioners, that's the petitioner local authority, is as follows. The petitioner's concerns in respect to the first respondent arose during the course of her pregnancy with the child. And then he explains a little more. And at the bottom of that paragraph, he says, it's fair to say on the basis of the evidence, the primary source of the petitioner's concerns in relation to the child arose as a result of the relationship between the first and second respondent.
This is in fact a quotation from the agreed minute, isn't it? In paragraph 25 of his judgment.
No, I'm now in paragraph 7 on page 159.
The general tenor,
Yes.
paragraph 10 on page 159.
Yes.
That is a quotation.
I'm
from
sorry, yes.
Joint minute 55,
Yes.
as I understood it.
Well, no, actually, the joint minute number 35 is an account of the history. And what he's doing is going through some of the history as agreed, particularly from paragraph 5.
Yes, he's going through the agreed history, but it's a
Yes.
quotation. It's not paragraph 10 of his judgment. Paragraph 10 of his judgment is on page 157, isn't it? Oh, no.
Paragraph 10,
No,
157
no,
is-
I'm getting
is-
it all mixed up.
is a recitation of the joint minute.
Yeah.
It's perhaps not the clearest.
It's a bit difficult to understand which is quotation and which isn't.
Yes.
No, the square bracketed ones are him, aren't they?
Yes. Over there.
Thank you. Sorry, I'm glad I've had that clarified for myself. Yes.
Right. So he gives a general tenor, and he says the source of concerns is this relationship. And he says then at paragraph 11, there were 3 main causes for the petitioner's concerns in regard to the relationship between the first and second respondents, all of them arising out of perceived concerns about the behaviour of the second respondent. The first concern related to criminal charges of alleged sexual conduct by the second respondent brought in England in 2010. It was clear on the evidence these charges had been dropped within a short period of their having been made, probably sometime in late 2010, certainly a considerable time before the child's birth. On the basis of the evidence I heard, it would appear the complainer in the charges, a vulnerable female person who suffered from learning difficulties, had given inconsistent and contradictory accounts of her allegations to the police. As a result of this, the police, as the prosecuting authority in England, did not consider it safe to proceed with the charges. One further matter did arise out of these charges. After the charges had been brought before they were dropped, the second respondent was granted police bail. Evidence was led at the proof from an English police officer involved in the case to the effect the bail order had been contravened on 2 occasions. And he explains that.
He refers to alleged sexual conduct.
Yes.
Are we right to understand that, in fact, the allegation was of rape?
It's difficult to know.
Well, didn't you have, or you didn't appear at this stage?
No, I didn't. No.
But didn't the material indicate the precise charge that was being considered?
I think that was one of the problems.
I see.
Malone Jr. did conduct the proof, but there were different sorts of allegation at different sorts of stages, and that was one of the problems the police faced.
Very well.
Malone Jr. confirms there was at some stage an allegation of rape at some stage.
It is referred to somewhere.
Yes.
Distinct recollection reading it yesterday.
There was such an allegation.
Yeah.
Yes.
And then at the foot of that paragraph, the social worker responsible quite candidly accepted that these matters had been considered by her when making decisions as to how to write her report and the recommendations she would make. She accepted that notwithstanding the charges had been dropped, she considered them of importance and something she took into account when forming her views. The second concern relating to the second respondent was an allegation that he had said he had sexual thoughts about the first respondent's daughter from a previous relationship, that person being a child aged about 8 at the relevant time. The third concern in relation to the second respondent were threats made by him to social workers in August 2013 that he would kill a support worker and social worker in the event they refused to allow him, the first respondent, to have the baby after its birth. In the same vein, threats or a message of threatening nature made by the second respondent to the first respondent also in August 2013. These threats were reported to the police, were the subject of a criminal prosecution. and resulted in the conviction, which is noted at paragraph 7 of the joint minute number 35 of process. And we do now go back to the paragraphs in the joint minute on manuscript page 157 and to paragraph 7, not in square brackets. On 9th August 2013, the father was charged with the contravention of section 1271A of the Communications Act 2003. The charge narrates he sent MB a message that was grossly offensive or of an indecent, obscene or menacing nature. He was convicted and he was fined £135.
Do we know what the message was exactly, Ms. Cole?
Well, no, we don't. And there is confusion between the juniors who are involved in the case as to whether this was the threat to social workers. We know that it was a telephone call from the father to the mother. It wasn't to social workers. I've given the court, just as a separate page apart, the terms of section 127 of the Communications Act, because grossly offensive or indecent, obscene or menacing nature is simply the terms of the legislation. It doesn't tell us what was in the message.
How extraordinary the case should have got this far without knowing the substratum of this aspect of it, Miss Scott.
Well, that is one of the extraordinary aspects of the case and one of the reasons we're here.
Very well.
The Lord Ordinary then gives an account of the evidence. The only part that I draw to the court's attention fairly briefly is in relation to the comment about the daughter, which makes clear at 16 that the original source of the information as far as the petition is concerned was the first respondent. So this is something the mother said, and she appears to have said it to a worker in the homeless unit, and I'll come back to that. But then if we go
But he
on...
seems to have admitted having said it.
Of something of that nature, yes.
Yes, because the position he adopted was to say he shouldn't have said this out loud.
Or something like that. Bear in mind, my lady, this is a learning disabled man speaking in his second language, or perhaps even his third or fourth language. He's a Tamil speaker. I'll come back to it. On manuscript page 163 at 19, the Lord Ordinary says, the result of all this evidence was that whilst it was plain there were no criminal proceedings brought against the second respondent, there was evidence which this court required to consider in relation to the relationship between the second respondent and the female person who had made the allegations against him. Furthermore, it also appeared to me there was evidence before the court to support the proposition the second respondent had breached bail conditions imposed upon him during the time the charges against him were live. The breaches appear to have occurred twice, once where I infer from the evidence he allowed the complainer into his house. She'd come to his house and asked to be let in, and he let her in. And second, where in his own evidence he accepted entering premises where the female complainer was studying. He'd gone to her college. He was also a student at the same educational institution, but perhaps not at the same site. He'd gone to the college. And then at 20, the Lord Ordinary says, I require to consider the implications of this evidence. And if I can take that paragraph up about 2/3 of the way down to the key passage where he says, in these circumstances, it appears to me to be established on the balance of probabilities that the concerns harboured by the petitioners in relation to the second responder's sexual proclivities were justified. In arriving at that conclusion, I should make it clear I am making no finding in relation to whether or not the sexual allegations made in 2010 were true or not. The relevancy or otherwise of these allegations is not a matter for me, nor have I heard any evidence in relation to the relevancy of these matters. My finding is confined to concluding that notwithstanding the lack of any criminal conviction, there was material available to the petitioners at the time of the child Evie's birth relative to the second petitioner's behaviour towards vulnerable females, which they could not ignore and were required to have consideration of when formulating a policy or plan towards the ongoing care of the child Evie.
So he's making a finding that the authority was concerned. That is based, you say, on an impression that, or if you like, a finding made by the authority, but he's not prepared to endorse it.
No, exactly, absolutely. So there's no finding about these allegations of criminal conduct. And even if one looks to it, this is about a relationship this young man had with a learning disabled person of the same age. It doesn't involve children, it's an adult female. It's not females, plural, and that must be a slip there. And there's no finding that his sexual proclivities, as the Lord Ordinary puts it, were in any way abnormal or violent or abusive. He'd just had a relationship with a young woman. And there was no finding that he'd behaved in a sexual manner towards a child. And the breaches of police bail, well, she'd come to his house and he'd seen her at college. And so it's difficult to know what to make of that, and I'll come back to it. But then he goes on and he says, in paragraph 21, similar considerations apply in respect of the allegations about the second respondent's threats uttered against social workers in the employment of the petitioners and his alleged utterance of a remark which could be construed as amounting to sexual interest in a minor. Now, one has to take it that the Lord Ordinary has chosen the words could be construed fairly carefully because he has some difficulty in making a finding. This is
the difficulty about that sentence is he's talking about allegations about threats,
yeah.
but they'd been admitted. He's talking about the alleged utterance of a remark, but it had been admitted.
Well, I think the difficulty with the remark is he says could be construed. We don't know what the remark actually was.
No, we're talking about the threats against social workers.
Yes, yes.
I mean, quite clearly they were made, and there is a finding that they were made.
Oh, absolutely.
And it is a finding of some significance, given that this child would need the input of social workers to have any chance of flourishing.
Indeed, but of course one would look at that remark differently if this man had been guilty of any violent or sexually abusive behaviour towards somebody else. If it was simply a comment made on the phone to his girlfriend, which is on one view what it was, then where does it take us in terms of relationships unless the man has been in any way abusive or unpleasant to the social workers themselves?
The remark he was alleged to have uttered was that he would like to have sex with this 8-year-old child. It could hardly be construed otherwise than as amounting to sexual interest in a minor.
Well, let me just look at that, because this is a remark made by a learning disabled man not in his first interest to a learning disabled lady who repeats it to a homeless worker, and somehow that is picked up by social workers. The Lord Ordinary is unable to make a finding as to what the remark actually was.
No, but I mean, the point is, he doesn't make any finding as to what may have been said, but the allegation, the alleged utterance of a remark, which could be construed as amounting to sexual interest, well, the alleged utterance was of a remark that he'd like to have sex with the child.
Or possibly that this was a very attractive young girl and she'd be great to have a relationship when she was older. Who knows?
Well, he gave evidence, didn't he? What did he say about this?
Well, the Lord Ordinary's view on his evidence was he really couldn't be relied on. Nothing could be taken from his evidence because he was all over the place.
Well, leave aside what the Lord Ordinary's impression was. Did he give evidence about this particular remark that he's said to have made?
It was put to him, yes.
Sorry?
It was, yes, the remark was put to him.
And what did he say?
I can just find that.
Well, at paragraph 16, at a meeting Elizabeth Hackett and her manager had with the second respondent, the position he adopted was to say he should not have said this out loud.
Yes.
I think that's the only finding of fact we have.
Yes, I think that's probably right. Yes. But he's learning disabled, and in his evidence he's unreliable. The mother says, well, he either didn't say it or it was a joke. And she's labelled by the Lord Ordinary as naive. And one has to say, well, what is actually the finding? And one moves on from that.
But she reported the matter to the police.
And then withdrew the allegation.
Indeed.
But we're no further on as to what evidence he gave before the Lord Ordinary about this.
No. And the Lord Ordinary has a whole passage about the difficulty of taking anything from his evidence, given that his evidence conflicted with his affidavit.
Well, that's one view, but I mean, if the man had said in evidence, yes, I accept I said that, that might well be a matter of quite pivotal importance.
I'm told by my learned junior he denied it in evidence.
He denied it, I see.
Denied the remark.
Yes, that's what I'm told. And one could well see a learning disabled man being faced up with this with a social worker and just saying the first thing that came into his head. The important point is that the Lord Ordinary required to make clear findings in relation to these three areas. And we do not find in my submission clear findings in relation to the accusation or the allegation, or for that matter the threats, other than that I do accept there was a conviction under the Communications Act in respect of a telephone call to the partner. But that's where the clarity ends. And there's no finding that he was in any sense otherwise obstructive or rude or violent, or that he's harmed anyone. And what the Lord Ordinary makes of it, he tells us, first of all, in paragraph 22, it follows from the foregoing that there was, in my view, plainly established before the court evidence of the concerns which caused the petitioner to proceed down the route of permanence, which ultimately led to the presentation of this petition to the court.
Well, your point is, isn't it, that throughout he talks about the local authority being justified in having concerns,
Yes.
rather than talking about, and this is what the court finds in relation to those concerns. That's your whole point, isn't it?
Absolutely, absolutely. There is a second line of defence for the local authority, where they say that in any event, these parents wouldn't have had parenting capacity. Although that's not the primary issue, in my respectful submission, the Lord Ordinary's decision is equally unsatisfactory in relation to the issue of parenting capacity. And we can see that from paragraph 23, where he says, 3 lines down, the social worker primarily responsible for this case, who was the main witness for the petitioners, was clear the views of the petitioners in this matter were critically based upon the consideration of the factor that the first and second respondents were a couple, with the first respondent making her position clear she would not break up this partnership. There was evidence before the court the respondent social worker had discussed the first respondent's relationship with the second respondent, making it clear that if she left him, the petitioners would reassess the case. It was appreciated the first respondent herself had difficulties in caring for an infant child. It was, however, considered that efforts could be made to assist her and thereafter assess her suitability as custodian for the child. So parenting capacity did not rule out this mother. It was her relationship with the father that ruled her out. And as for the father, there is an admission in the joint minute that the local authority had made no formal assessment of the father's parenting capacity.
But it said, paragraph 25, about 10 lines from the end, that in fairness, it was not suggested on his behalf that he was able to demonstrate the necessary parenting skills required for the care of the child.
No.
Well, that's what it says. I've just read out what it says.
But why should he? I mean, to be a parent of a child, you don't have to say, I have parenting capacity. It's for the local authority to prove their case and prove that he doesn't have parenting capacity. And they'd never assessed him.
The Lord Ordinary, what does one take from his telling us that it wasn't suggested on behalf of the father that he was able to demonstrate the necessary parenting skills? But he didn't have the ability to demonstrate that he had those skills.
That is taken from the evidence called from Dr. Wolfson. Dr. Wolfson was called, and he saw this man with his little girl. It's the only time he's seen her, and gave evidence to the court that this man was capable of developing a bond with his child. But on the basis of that evidence, one couldn't possibly have said that this man has parenting capacity. It was just a contact visit.
And Dr. Wolfson's evidence was rejected in any event?
Well, maybe not, yes. I think that I'm not sure that it was rejected, but
limited assistance
yes,
was gained.
Indeed, yes. But the Lord Ordinary was not in a position to say that this man did not have parenting capacity.
He says, I placed little weight on Dr. Wolfson's evidence in this case.
Yeah. But in my submission, the point that this father has had so little contact with this child that he can't say, there is evidence that I can be a parent, is neither here nor there, because it's up to the local authority to establish that this man doesn't have parenting capacity, if that is their case. And what has happened in this particular case, as must be painfully apparent, is that they've written off this man on the basis of their concerns. They have deliberately not assessed him as a parent, and that was agreed in the joint minutes, number 35 of process, at paragraph 25. And that's been the end of the matter. Well, the paragraph 25 of that joint minute is on manuscript page 158. It's the last paragraph in the joint minute.
Thank you.
How usual is it for a father, a birth father acknowledged as such, not to be granted any contact at all with his newborn child in Scotland? Is that normal?
I don't think I can answer my lady's question. What has happened here was this little girl, on the basis of these concerns,
Yeah.
was taken at birth.
She was removed at birth, but in such experience as I used to have in this area south of the border, yes, children are from time to time taken at birth on the basis, and properly so, on the basis of reasonable suspicion or reasonable belief that the grounds for making a care order will be made out. But it is usual to make sure that there is some opportunity for a relationship to develop between each parent and the child,
Indeed.
in case those suspicions turn out to be unfounded.
Well, indeed.
That's the normal state of
Yes.
affairs. So I was staggered to read here that this father had only been allowed one visit when the baby was really quite old.
And in consequence of an order of Lord Brailsford, as I understand it, once the permanence proceedings had been put underway, it probably wouldn't be, one would hope it wasn't normal, but I've seen it repeatedly.
Well, can the children's hearing do anything about it? Can the children's hearing, they can...
Well, of course the children's hearing can do something about it, but they act on the advice of the local authority, and there's an issue about that here too.
Yeah.
It was an order, wasn't it, made by the sheriff? I'm looking at paragraph 9 of the joint minute on page 157. That on the date of the child's birth, a child protection order was granted at Livingston Sheriff Court with a condition that there be no contact between the child and, it says MV, but I think that should be KV.
Yes.
Yes. What I'm told by my learned junior is that order having been granted, on the application of the local authority, the children's hearing then perpetuated the position throughout. And of course, the permanence order application in this case was made just before the child's first birthday, and the matter then became an issue for the court. The children's hearing were not in a position to change matters once the matter was brought before the Lord Ordinary in terms of a permanence order application.
The order to which Lord Reid refers was made on the date of the child's birth.
That's right.
Yes,
Was it made without notice to the parents?
yes, as I understand it. It is normal that it is made without notice, and it would have been made without notice. But the children's hearing, the second working day children's hearing, the parents would have had notice of.
That's the 3rd of January
It would be.
hearing, yes.
And in paragraph 14, we're told that 6 months later, the child was made subject to a compulsory supervision order with a measure, as it's called, that she shall have no contact with KV. Is that who makes the compulsory supervision order?
The children's hearing.
Children's hearing.
Yeah.
Miss Scott, I'm sorry to be so ignorant, but could you very briefly explain the difference between a child protection order, a compulsory supervision order, and a permanence order?
Of course. A child protection order is an emergency order granted on the application of the local authority, usually by a sheriff, under section 38 or 39 of the Children's Hearings Act, and that is in volume 2, as I understand it.
We needn't look at it.
Yes, it's on the basis of reasonably suspects or reasonably believes, depending on whether one wants to assess or whether one wants to remove. But it is on the application of the local authority. The matter is then referred to the principal reporter, and the local area reporter will decide whether to frame grounds of referral to the children's hearing and bring the matter before the children's hearing, which, as my lady and my lords may be aware, is a lay panel of 3 persons. And they will then decide, they will then hear from the parents whether the grounds for referral to the hearing are accepted. If not, they will send the threshold test off to the sheriff to determine whether it's established. If it's accepted or if the threshold test is established, the children's hearing, the lay panel, then makes a decision whether there should be a compulsory supervision order.
Does that replace the child protection order?
The child protection order is replaced after 8 days by an order which is an interim compulsory supervision order.
All right.
Used to be a place of safety order, but it's now an interim compulsory supervision order.
Thank you.
And when you say supervision, it's of course can include care.
It does, yes, yes.
Almost invariably.
Well,
Not almost invariably, but in this sort of situation, of course. Although it said supervision, basically it was a
in
foster
Scottish
placement,
terms,
wasn't it?
it's accommodation.
Yes.
So the child is accommodated. And this child was accommodated essentially from her birth. So she's
So
accommodated.
first of all, we get a child protection order.
Yes.
Then within days, we get an interim compulsory supervision order.
Which is the
Then
children's
6
hearing
months
decision.
later, we get a compulsory supervision order.
After the threshold test for the children's hearing has been established, the children's hearing can then make a compulsory supervision order. And that can last for a maximum of 12 months without review. So it's a short-term order that suspends the exercise of parental responsibilities and rights, doesn't take them away.
Well, then what happened? Because the Lord Ordinary only made his order in March 2016.
Yes.
More than a year had passed.
What happens then is that the child remains on the compulsory supervision order, but the children's hearing cannot alter that order. The situation is effectively frozen other than any orders that the court makes. There was a concern when permanence orders were instituted that there was dual decision-making going on between the children's hearing and the court while the two processes were together. And what happened in the Adoption of Children Scotland Act at section, I think it's 96, is the court is given power to make interim orders and the children's hearing cannot make changes unless authorised to do so by the court.
So the compulsory supervision order made on the 12th June 2014 would have expired on the 12th June 2015.
But it rolled on.
It rolls on.
It rolls on, but without change.
I see.
And
until
then,
the permanence order is
until
made.
the permanence order. And
Then it's replaced by the permanence order.
essentially, yes. And when we come to look at the permanence order, we'll see that what the Lord Ordinary did was terminate the permanence order, which is what he's normally required to do.
Terminate the permanence order.
Sorry, terminate the compulsory supervision order, which is what he's normally required to do in terms of Section 89 of the 2007 Act.
Miss Scott, thank you.
And can I ask one more thing? What is the Adoption and Permanence Panel?
The Adoption and Permanence Panel is a local authority panel, which is essentially an internal decision-making body within the local authority that decides whether this sort of application is to be made.
We have those here as well.
Yes, they're universal in the UK.
And the Looked After Children Reviewing Hearing, is that another local authority?
It is. It's held under Section 39 of the Children Scotland Act of 1995. It's an internal review mechanism of how this accommodation is going and whether, indeed, the matter should be referred to the adoption panel or adoption and permanence panel.
There's one other interesting thing about all of this. The grounds for referral.
Yes.
Were they admitted, or did they have to go to the sheriff to be proved?
They went to the sheriff to
That's
be
what I
proved.
thought.
It is, and my lady's put a finger on a very difficult point here. This is the point that should have been taken then. It wasn't.
And do we know what the findings were of the sheriff court?
Well, they're not recorded in the Lord Ordinary's decision.
They're not, but presumably somebody knows what they
Yes,
were.
oh yes, yes. The grounds for referral established were on the basis of Section 67(2)A and E, which were that lack of parental care was likely to cause this child's serious impairment to her health and development, or that she was in a household associated with a person under E to the same effect. And so the decision which the court makes today is capable of reflecting back into those hearings.
But are you saying that in a case where the primary complaint is no proper findings of fact made, are you saying that there were findings of fact made by a sheriff, which for some reason haven't seen the light of day?
No. My understanding is that the grounds for referral to the sheriff were based on very similar evidence.
Yes, but the sheriff must have made findings of fact, because that's what he's for in this situation. How could he find them established if... and do the sheriffs give reasons for their finding the grounds established?
I don't think there was a written decision. There was no written decision from the sheriff. The sheriff would have done an extempore decision. It's unsatisfactory. I've recorded that in the case.
The paragraph 13 of the joint minute on page 157 tells us that amended grounds for referral were established after proof. Production 651 is the interlocutor pronounced that day, and 652 is the amended grounds
Yes.
for referral. It might be helpful for at least those to be before us.
Exactly. I had marked that paragraph saying we'd like to see those.
They were not before the second division. I can assure the court
They were
of that.
before the Lord Ordinary.
They were before the Lord Ordinary, yes.
And that's why I was asking, again, I'd marked, do they give reasons? Sounds as if they don't. But
No, there is no written decision of the sheriff.
on the other hand, amended grounds for referral, that sounds as if something happened in the course of a hearing before the sheriff to cause the sheriff, whoever that was, so I'm not attributing a gender to the sheriff, to possibly amend the grounds that the local authority had put forward.
I don't know who effected the amendment, whether it was the reporter or the sheriff.
Now, I could take the point that technically this isn't res judicata because the parties are not the same. But on the other hand, if there has been a hearing where findings have been made on the basis of the evidence in front of the sheriff, that surely has to be relevant to the decision made by the Lord Ordinary or a subsequent sheriff on a permanency proceedings.
One would have thought so. And it doesn't feature in what the Lord Ordinary is saying here. He seems to have accepted that which counsel said to him, which is this is not res judicata. You have to look at the evidence yourself. You have to make what you will of the evidence which is before you in this case rather than that case and make a decision.
Well,
Yes.
this may be an interesting point of law, but it would be difficult to think that the findings made by the previous sheriff were not relevant to the findings to be made by the Lord Ordinary.
One would have thought so, but
You would accept that, would you, Mrs. Scott?
I couldn't accept it as I stand because I'm conscious that all the Julias involved in this case said this is not res judicata. You have to listen to the evidence. You have to make a decision on
I'm not suggesting it is technically res judicata, but that doesn't mean to say that the previous findings are not relevant and part of what the Lord Ordinary can take into account.
And he hasn't. As I understand it, nothing was established beyond allegation and concern.
But that can't be sufficient for a grounds for referral.
No, it can't.
Can't.
It can't. And my concern, having got this case at the appellate stage, was that we were in a situation where allegation and concern had formed the basis of bringing this child into accommodation, and we were still in the range of allegation and accusation and concern. And it would be a pity if one were to look at this case and reflect back on something which hasn't been litigated and where one doesn't quite know what the sheriff has done.
Do the Sheriff Court rules dispense with the need to give a written judgment? In a
Yes,
case of
one
this
can give an
kind?
extempore judgment, and one only gives a written judgment if one's required to do it. It's usually a stated case. It's essentially a summary process in what can be a very serious matter. Yes. And one only really writes this up if one's asked for a stated case. Or is only required to write it up if asked for a stated case. I know. Right, well, I might turn to the Lord Ordinary and to paragraph 28, where he says, on the basis of the foregoing, I am of the view that the grounds in the petition have been established.
Which paragraph? Sorry.
Paragraph 28, manuscript page
The
165.
final paragraph, yeah.
Yes, it is. I'm of the view that the grounds in the petition have been established. I'm satisfied that both for the safety and welfare of the child throughout her childhood, it's necessary that the orders should be granted. In the circumstances, I will grant the order sought in the prayer of the petition. Well,
And is there any point at which he rehearses the principal provision which he was being asked to apply?
no. Well, at the beginning of the judgment,
But does he actually set it out?
no.
He merely makes a reference to the TW case,
Yes, he does.
from which one can get an order of a logical order for approaching the problem,
Yes.
but he doesn't then go on to approach it in that logical order.
No, it doesn't.
He says section 84.5 sets forth certain steps the court must take before granting an order.
Yeah,
And that's all he says
it is.
about this principal thing that he has to apply.
Well, it's actually not the only principal thing. What he says is, in terms of sections 84.1, he actually gets it wrong. 84.1 is not relevant to the circumstances of the case. 82, I think he means 84.2 is relevant. Well, it's not. It only applies to children over 12 who are incapable of giving consent. So he's got that wrong. Sections 84.3 and 4 provide that in considering whether to make an order, and if so, what provisions the order should make, the need to safeguard and promote the welfare of the child throughout child is a paramount consideration. Well, that may be section 84.4, but it's not 84.3. And then section 84.5 sets out 4 certain steps. I'll come on to this because he really hasn't got the point quite in my submission. And of course, he's not just dealing with a permanence order. He's dealing with authority to adopt in this case. And we know he's got that wrong because the local authority has conceded he's got that wrong. And so when he says the grounds in the petition have been established, no, they haven't. And it's conceded that at least part of those grounds have not been established because he hasn't found, as he was required to do, that there was a likelihood that this child will be placed. And what we know about this poor 3-year-old is that she is mixed race and is likely to be suffering from global developmental delay, and attempts to place her so far have failed. Mm-hmm. So it's a very sad case.
It's a terrible case.
Yeah, indeed. And her father does actually want to see her. But if one looks at this, I mean, what does he mean by safety in that passage? What's he driving at? Is he saying there's a real possibility of child sexual abuse? And if so, how? Why? Is he deriving a possibility of some other harm? And if so, what harm is it? Is it serious? What's his basis? And then he talks about welfare. This is not in the first instance a straightforward welfare test. We've got a threshold test. How do we know his decision really complies with the law? And this is not with respect legalism. And I refer briefly with gratitude to Lord Wilson's comment in the Ray case that logic is the lifeblood of the law. Where's the logic in this? And that takes me, finally, to the Adoption of Children Scotland Act, which is in volume 1 of the authorities. Tab 3, manuscript page 188. And I'm referring to this for the list of decisions which the Lord Ordinary was required to take. Section 80, which is on the first page, sorry, beg pardon. This is on page 169. Section 80. The appropriate court may, on the application of a local authority, make a permanence order in respect of a child, and that's an order which consists of a mandatory provision, ancillary provisions, and, if asked for, authority to adopt. And if one looks at the following page, section 81, the mandatory provisions are, if one takes B first, regulation of the child's residence, who regulates residence, and then A is provision of guidance. Is the court familiar with the Children's Scotland Act of 1995?
Familiar will be putting it too high.
Perhaps I'd better just then take the court very quickly to tab 3.
I've read the provisions in tab 3.
That's basically your private law.
It is. And what the 2007 Act draftsman has done is provided for the allocation of the private law parental responsibilities and parental rights in the course of the permanence order, and has said that in terms of section 80, they all have to be residing somewhere. They all must vest somewhere. And so section 82 deals with ancillary provisions, and this is designed to be a very flexible provision to allow the court to make an order which is tailored to each child personally, and to who should hold responsibilities and rights in relation to each child, with the possibility of sharing between the local authority and the parent, the local authority and the foster parent and the parent. as is appropriate to each child, other than the right of residence, which goes to the local authority. And I'll come back to that. And 83 deals with authority to adopt. What the Lord Ordinary left out and is accepted to have left out, 83(1)b, satisfaction that the child has been or is likely to be placed for adoption. It's not there. And that's why the local authority has been unable to sustain that part of the order, but it was within the Lord Ordinary's decision.
So can I just understand this? A child can be placed for adoption before an order is made granting authority for adoption.
Yes.
So would a local authority need a permanence order in order to place?
No. But what a permanence order does, a permanence order with authority to adopt replaces the old freeing order. So it deals with the dispensation of parental agreement to adoption within the context of local authority proceedings, and it means that the adoptive parents don't have to grapple with dispensation with parental consent. And I think Lord Reid will recognise that the terms of Section 83 are very similar to Section 31 that the court dealt with in S against L. And if one looks at that, the grounds are, for the present purposes, the Lord Ordinary was looking at whether subsection 3 applied, and that's whether the parent had parental responsibilities and rights and was unable satisfactorily to discharge or exercise them and was likely to continue to be unable to do so. But interestingly, one can only move to D, if neither of those sections, if subsection 3 does not apply. So the welfare of the child otherwise requires consent to be dispensed with. Only applies if you have not found that the parents are unable to discharge their responsibilities and rights. And that's another area where there's confusion, as we'll see, in what the Lord Ordinary has done. And I accept that these are tricky decisions to write. They're quite complicated to take oneself through all these different aspects and consider each parental responsibility, each parental right, the issues raised by the authority to adopt. And what's difficult about this is the Lord Ordinary simply hasn't done it. He hasn't taken himself through these rather complex steps. All we have is the very brief 3 lines at paragraph 28 of his decision. If I can refer very briefly, if I may.
Ms. Scott, do you have in Scotland the facility for an advocate respectfully to say to a judge, thank you very much for your written judgment. I wonder whether you would see fit to expand paragraph 23.
No. He issues his interlocutor. He writes the opinion to justify his interlocutor, and that's it. And if my Lord is interested in the interlocutor, it's in the core volume just before the Lord Ordinary's decision. At manuscript page 152. It shows to some degree the confusion. For some reason, he starts with dispensation with consent, albeit that's a function of a permanence order, not the main thing. And
is this drafted with the help of the advocates?
No, it's simply drafted by the court. He confuses the dispensation with consent on the basis of inability to discharge responsibility.
Page are you reading from, please?
152.
Thank you.
And he refers to welfare, although that wasn't part of the test, given that he'd found the first part established. So one worries about his reference in paragraph 28 to welfare. He deals with the mandatory provisions, he deals with ancillary provisions. He then proceeds to grant authority to adopt and orders the compulsory supervision order cease.
Yes, in Scottish practice, the parties aren't normally involved in the drafting of interlocutors, but once the judge had drafted his judgment,
Yes.
his clerk would then prepare a draft interlocutor for the judge's approval, and it may be revisal.
Yes. In this case, there was actually a motion by the respondent local authority for remit to the local authority to the Lord Ordinary to further explain his judgment. That was refused.
Oh, I see. Oh. I thought you said that couldn't be done.
Well, it can't be done, and that's why the second division refused it.
Well, thank you.
just dealing briefly with what these orders are supposed to be about. They were the creature of the Adoption Policy Review Group, and the report of that group is in volume 2 at tab 28, the very end of the second volume. And the court has the chapter which deals with the recommendation. At manuscript page 888. That these were orders, as is said at paragraph 5.1. The group considered the legal arrangements for children who cannot safely return home to live with their families. And that's what these orders are about. Children who are not going to go home. They draw a line underneath the possibility of going home. And if I can take the court very briefly to paragraph 5.12, that reinforces the point. And the issue of flexibility to suit the circumstances of each child. And the recommendation for a flexible order at 5.14. At 5.25, the test, which is recommended. There's no one with parental responsibilities or parental rights, or residence with any of the persons who have parental responsibilities or parental rights is likely to be seriously detrimental to the child's health or development. And then there are other circumstances apart from the child's safety in which it may not be desirable for a child to live with its birth family. For example, the child may have no relationship with its birth parents because of previous episodes of care. However, the group considered a high test was required to justify the making of an order, the minimum effect of which would be to remove the right to have the child live with them or regulate the child's residence from birth parents of the child. And then at 5.27, normal overarching principles concerning the orders should apply. And if one goes back and looks at section 84, what one has there is essentially the overarching principles, which in Scots law are the welfare of the child is paramount, that there should be no order unless it be better for the child, and then that the child's views should be considered in, if the child wishes to give them, should be considered in making any order. And those are all reflected in section 84. The section had a rather difficult parliamentary history, and it's in the appendix. I'm not proposing to visit it, time doesn't permit. But it's mentioned in the Sterling case in volume 1 at tab 9. The case starts on page 489. And the passage where Lord Drummond Young, giving the opinion of the court, deals with this is on page 493. At paragraph 13. He says, thus, section 84 imposes two critical conditions for a permanence order to be made in a case where the natural parent doesn't consent. And then he recites the no order principle and the welfare principle. Secondly, in terms of section 5C2, the court must be satisfied that the child's residence with the parent is or is likely to be seriously detrimental to his or her welfare. Of the two conditions, that in subsection 5C2 is more fundamental. It imposes a threshold test. Unfortunately, he then goes on with an error because there's no question of parental consent in relation to the permanence order. That only applies to authority to adopt. But it's only if the test is satisfied the court requires to go on to consider the welfare of the child, and he mentions TW. At 14, the importance attached to the threshold test in subsection 5 in TW is reflected in other decisions, notably the decision of the UK Supreme Court in the English case of Ray B. Care Proceedings Appeal, per Lord Wilson and per Lady Hale. The fundamental point is that depriving the parents of a child of their parental authority at common law is a most serious matter, and it should only be done if strict criteria is satisfied. This is made clear in the speech of Lord Templeman in Ray KD, and it is cited by Lady Hale in Ray B in the very familiar passage that the best person to bring up a child is the natural parent. It matters not whether the parent is wise or foolish, rich or poor, educated or illiterate, provided the child's moral and physical health are not endangered. That is based on general common law principles, and provided these are satisfied, it's generally unnecessary to consider Article 8, and he refers to Lord Neuberger in Ray B. The threshold test is, in our opinion, a matter of fundamental importance, and we must express regret at the manner in which Section 84 of the Children of Scotland Act is structured. And he goes on to give an explanation of the unfortunate parliamentary history. So what we've got is the fundamental test tacked on to a sub-paragraph dealing with an overarching principle about dealing with the views of the child, when this is actually the central and first consideration for any court dealing with such a case. Turning on to Lord Drummond-Young's addressing the particular problems in the Stirling Council case, he looks at what the Sheriff has done at paragraph 19 on page 495. The Sheriff's findings in fact and law are set out at paragraph 10. So far as a permanence order is concerned, the critical findings are: it would be better for the child a permanence order is made. It should not. The child's residence with the respondent is likely to be detrimental to the welfare of the child. It is the second of these findings that appears to be intended to address the threshold test found in 84.5c2. It does not, however, address the strict criterion that paragraph adopts, namely that the child's residence with the natural parents is or is likely to be seriously detrimental to the welfare of the child. We have already emphasised the importance of this criterion. Mere detriment to the welfare of the child is not enough to satisfy the threshold test. Serious detriment is required. While the question of serious detriment involves an evaluative exercise largely dependent on the facts of the particular case, it's essential that legal components in that exercise should be properly addressed. And the court comes to the conclusion the Sheriff in the Stirling case, simply by failing to deal with severity, seriousness, has erred. And the court then required to address anew whether that test was satisfied. And in fact, the Sheriff had made sufficient findings for the division, the extra division, to address the threshold test in the Stirling Council case. Now, what of course is interesting for me in my argument is the equivalence that Lord Drummond-Young draws between a Scottish permanence order and the test for a care order under Section 31 of the Children Act of 1989. And if I might now proceed to have a look at Section 31, I don't propose to take the court to it. I'm assuming it's very familiar territory to the whole court. But my position on this is that the similarities of function and language between the test for a Scottish permanence order and the test for a care order are so similar that the court's decisions on Section 31 cannot be ignored in applying Section 84.5c2, and that it would be highly unfortunate if different standards operated on the two sides of the border for what is a very similar issue. A measure of consistency is, in my submission, desirable. Perhaps I should have opened, probably for my benefit, Section 31 in tab 2 on page 184. I accept, of course, that the two sections, Section 31 and Section 84, are slightly differently framed, but they serve the same function. They represent a threshold test which must be crossed before state intervention is justified. And that is what appears to have impressed Lord Drummond-Young in the Stirling case. Even though the English care order need not lead to care, accommodation away from home, whereas a permanence order will inevitably lead to accommodation away from home. So in that sense, the argument here for the importance of the threshold test is a fortiori of the Section 31 position.
You could draw the analogy, but I'm not sure that we have it here, with what is possibly a closer analogy in the Adoption and Children Act, which is the threshold test for making a placement order. A placement order being the equivalent of your permanence order with authority to adopt. Because, as I recall it, I would need to make sure my recollection was accurate, that does require that the Section 31(2) conditions have been met, or there is consent to the making of a placement order. So we have the same threshold at that stage. It may have been previously established in care proceedings, or it may not have been, and now has to be established. So you do have the Section 31(2) being used both for the purpose of the original care order or supervision order and for the purpose of a placement order.
I'm grateful to my lady. I see the
I
point.
think that,
made.
that
I'm
reinforces the
not in a
analogy that you're drawing.
position- I'm not in a position to look at that expressly, but I'm grateful. I'm sure that's right.
I'll set about checking it.
Have a look. But what this is a bulwark against state intervention of the order, and it is of no protection at all if it proceeds simply on the basis of suspicion. And that, of course, is well established in the line of authority which led to In Re J. And again, if I can go back to the B case in tab 4 of the second volume, and to what my lady said in that case. First of all, in relation to something which had been said previously by Lady Justice Butler Sloss, and this is manuscript page 612, and it's in the case of M&R minors sexual abuse expert evidence. Where a local authority were contending that essentially suspicion of sexual abuse should be taken into account. And what Lady Justice Butler says, with the approval of my lady in the chair, they amount to the assertion that under Section 1, the welfare of the child dictates that the court should act on suspicions or doubts rather than facts. To our mind, the welfare of the child dictates the exact opposite. If there is a dispute as to whether the child has suffered or is at risk of suffering harm, the task of the judge, when considering whether to make any order, whether it be a care order or supervision order under Section 31 or Section 8 order, residence contact and the other orders with respect to children, must be to resolve that dispute. The question is how such a dispute is to be resolved. To our minds, there can only be one answer to the question, namely the same answer as was given by the majority in Re H. The court must reach a conclusion based on facts, not on suspicion or mere doubts. And of course, my lady goes on to reject the attempt to pull back from in Re H. And the court there in Re B roundly rejects that, and that's at paragraph 54.
It's section 21, subsection 2 of the Adoption and Children Act 2002, which provides that the court may not make a placement order in respect of a child unless A, the child is subject to a care order, which presupposes that Section 31(2) threshold has been crossed, B, the court is satisfied that the conditions in Section 31(2) of the 1989 Act are met, or C, the child has no parent or guardian. So this, yes, it is being used, and in England you can't place a child for adoption without either parental consent or a placement order. Mm-hmm. So the authority that you require to make a placement order has to be Section 31(2).
Yes, whereas we allow our children to be placed essentially because they're in the children's hearing system.
Yes. Yes. Well, I'm not making any comment about which is the preferable thing. I'm only making the comment that Section 31(2 you are correct to say that Section 31(2) performs the same function in England and Wales.
I'm grateful.
As Section 84.
So the court has my point about bulwarks against state intervention. That's the obvious point. But the other point to make about these two sections is they both involve the language of satisfaction. And, of course, that carries the implication that they must be judicially satisfied on proper material. And what I'm borrowing there from is Lord Nichols in Re H, when he deals with this in Volume 1, tab 6, at manuscript page 314. He has a passage which is headed the burden of proof. The power of the court to make a care or supervision order only arises if the court is satisfied the criteria stated in Section 31(2) exist. The expression, if the court is satisfied, here and elsewhere in the Act envisages the court must be judicially satisfied on proper material. There's also inherent to the expression an indication of the need for the subject matter to be affirmatively proved. If the court is left in a state of indecision, the matter has not been established to the level or standard needed for the court to be satisfied. Thus, in section 31.2, for an order of the threshold to be crossed, the conditions set out in paragraphs A and B must be affirmatively established to the satisfaction of the court. The legal burden of establishing the existence of these conditions rests on the applicant for the care order. The general principle is he who asserts must prove. And that's, of course, the normal principle, as he goes on to say at the end of that paragraph. The other point, next point to make, is that in both of these sections, there is a juxtaposition of likely and harm. Likely and harm in section 31, likely and detriment in section 84. And if one's looking at a prediction of future harm of that nature, that invokes in my submission Lord Hope's golden rule for In Re J, and I've set it out as the very first comment under the first issue, my case. So I'm not going to go back to it, but it's there and the point is made. Both these sections in my submission impose a test of severity. One talks about significant and the other talks about serious, but they're closely related, and as Lord Drummond Young says, both involve an evaluative exercise, an important evaluative exercise dependent on the facts of the case. And we've already looked at Lord Drummond Young in Sterling, but if I might also adopt, and for the sake of time refer to briefly, Lord Wilson in Re B, at volume 1, tab 4, paragraphs 26 and 27, where my Lord uses serious interchangeably with significant. They have the same connotation. And they both link to the parent. Now, I accept, of course, that section 31 imposes a test of harm attributable to parental care. But the test in section 84 is that residence with the person with parental responsibilities and rights, which is generally the parent, is likely to be seriously detrimental to the welfare of the child. That is, the possibility of serious detriment is attributable to residence with the parent. And the causal connection is there, as indeed was recognised by Lord Drummond Young's Sterling Council case. Of course, I'm conscious that attributability, however one wants to pronounce it, is not a central part of the case, and I think it's acknowledged in Re J. There are a few cases where that aspect of the section is material. But in my submission, there is such a similarity of language and function between these two sections, it would be most unfortunate if they were differently interpreted and applied when it comes to establishing the basis for determination of the threshold test.
Is there another similarity? It occurs to me that you could cross the threshold in section 84.5 by finding that residence with one of the parents would be seriously detrimental, which would enable the court to make an order which would actually remove the parental rights and responsibilities of the other parent as well. That must be possible, theoretically. And the same is true under the Children Act.
Yes, but of course then one comes to the second stage and
Yes.
says...
Well, what do we do about it? What do we do about it? Yes.
Is this order going to be better for the child?
Absolutely.
Is it in the child's welfare? That's why it's important that there are both the threshold and the exercise of judgments,
Yes.
which has regard to Article 8, of course. I know. Can I pause to take issue with a part of the respondent's case here? And that is the part of the respondent's case in the core volume at page 117. At paragraph 25.1. And it's halfway down that paragraph, or perhaps I should start at the first sentence. It submitted the test, this is the respondent's submission, is sufficiently widely framed to include circumstances where the likelihood of serious detriment is not attributable to the standard of care given to the child. And then halfway down, in some cases such as the present, the quality of care likely to be provided by the parent to the child will be one of a number of factors relied on by the local authority to establish the likelihood of serious detriments. And there's a reference to the absence of bond being sufficient. In my respectful submission, the absence of a bond with the parent cannot of itself result in serious detriment. Children are regularly placed with carers or adoptive parents with whom they have no previous bond. There has to be more. I can accept that if the child has particular needs which a parent is not likely to be able to meet, the tests may be satisfied. So, for example, if you have a severely disabled child, or a child suffering from a particular medical condition that the parent wouldn't be able to cope with, that might satisfy the test, although that's an argument for another day. There is a current controversy, which in my submission it's not necessary to settle in this case, which is whether attachment to an alternative family means residence with a birth family is likely to result in serious detriment. That is, shifting the child from the alternative family back to the birth family. And three of the members of the court, Lord Reid, Lord Wilson and Baroness Hale, will recognise that this was an issue which was sought to be brought before the court in the Fife Council case, and for reasons connected with the facts of that case, the court determined shouldn't be addressed, albeit it was recognised to be an issue of some importance. And I've put before the court the brief decision of three members of the court. It's in a separate sheet apart in the Fife Council case. However, the point here doesn't arise, as this little girl is not permanently placed, and there is an issue about whether she will ever be placed. So we don't have the issue here of whether fundamental inability to manage distress of a broken placement is a relevant issue. But I'm simply flagging it as an issue which is open and for determination another day.
You say three of us know about Fife Council. Was it a permission to appeal?
Yes, my Lord has the decision in front of him.
Right.
It's one of the 3 sheets of separate paper. And the Fife Council case...
Where will we find that?
In front of my lady. I can see it in the front of the table.
You can see it in front on the table.
Yes, I think. Perhaps not.
Oh, yes.
Oh, was it along with the...
Yes. I'm sorry, I'm looking at the wrong document.
Oh.
Yes.
This was in the matter of EC.
Yes.
Right.
But going back to the task of the Lord Ordinary in a case such as this, I respectfully adopt what Lord Neuberger said in Ray B, and again, it'll be familiar to the court, that there are 3 stages to a threshold test. And this is taken from paragraph 50 of Lord Neuberger. 1, determine the factual issues. 2, identify the threshold. 3, decide whether on the primary facts found and the assessments the judge has made, the threshold was crossed. And in my respectful submission, this case falls at the first hurdle. Now, I appreciate I'm going to be short on time here, so if I can simply refer to Baroness Hale's judgment in Ray B, and to what she has to say at paragraphs 177, 179, 181, 187 and 188. What she says there builds on the line of the critical case for me, which is in Ray J, and I do need to visit that in volume 1 at tab 7.
Could you repeat Lady Hill's paragraphs again, please?
177,
Yeah.
179, 181,
Yes.
187 and 188.
Thank you very much.
I'm sorry, I rattled those off rather fast. In Ray J, tab 7, page 323. Of course, the leading decision in this case was given by Baroness Hale, and it starts after the Court of Appeal, so we start on page 362. And the fundamental point that in a free society, it's a serious thing indeed for a state compulsory to move a child from his family of birth. And yet it's also a serious thing for the state to fail to safeguard its children. And that entirely is accepted, of course. And then the purpose of the threshold test at paragraph 2. The point that at paragraph 3, this is the culmination of 6 previous cases. So this is the 7th, and of course it's a 7-justice decision. The previous cases are analysed in the appellant's father's case in Appendix 1. I don't propose to refer back to that analysis except to say that, of course, the 3-2 majority decision in Re H has been affirmed and reaffirmed now and is settled law. And then paragraph 4. A child may be protected not only if he's actually suffering harm as a result of lack of reasonable parental care, but also if it's likely he will do so in the future. But how is a court to be satisfied it's likely this particular child, the child concerned, will suffer serious harm in the future? It's twice been held in the House of Lords the mere possibility, however real, that another child may have been harmed in the past by a person who is now looking after the child, with whom the child is now concerned, is not sufficient. The court has to be satisfied on the balance of probabilities that this person actually did harm the other child. And that's back to In Re H and In Re B. But in both those cases, it was not established the other child had been harmed at all. And then at paragraph 15, I want to spend a little bit of time in this paragraph. The starting point is the decision in Re H. The proceedings concern 3 young girls whose elder sister alleged that she had been sexually abused by their mother's partner, her stepfather, and the father of the 2 youngest girls from the age of 7 or 8. The judge did not find the allegations proved, but held there was a real possibility they were true. And I pause there and say one could just as easily substitute for the words, there was a real possibility they were true, the words, the making of the allegation gave rise to concern about the stepfather's sexual proclivities. There really, paper cannot be thrust between the 2 sets of allegations. And then the decision of the House of Lords is authority for 3 important propositions.
Third one is the critical one for you.
Absolutely, absolutely. And of course, what is being said against me here is, and again, I'm taking the court to the case, is that proposition is essentially dangerous and absurd as far as local authorities are concerned, because that is what is said in paragraph 22.2 of the respondent's case. Which, of course, is an extremely bold assertion. And I answer it in this way. Of course one doesn't ignore allegations. Of course one doesn't ignore serious accusations. But the court is there to determine whether those allegations, those accusations are established as matters of fact. That's what the court is there for. And of course, as Lord Hoffman points out in the B case, establishment of fact is binary. It is or it isn't. It's established on the balance of probabilities. It's not established on the balance of probabilities. And if it's not established on the balance of probabilities, it doesn't exist as far as the court is concerned in its determination of the threshold test. And of course, I go back to what Baroness Hale said in the B case as well, in what was said in relation to Lady Justice Butler's gloss and the endorsement of In Re H. Here, if there was concern about the capacity of 2 learning disabled adults to parent this child, that should have been addressed. And the problem in this case is that the local authority reacted to the other matters and never assessed the father. Now, of course, I could go on through In Re J, but I'm conscious how many members of the court were involved in the case. The passages I was going to refer to were 16. The quotation from Lord Wilson when he was Lord Justice Wilson at the top of page 370. I was going to refer to 44 and 49, but I will move on quickly.
Yes, I mean 49 in particular, having adopted a flexible test of likelihood, it's important, all more important to hold that an objective factual basis was required from which to draw the inference.
Absolutely, absolutely.
That's the essence of your case.
It is. I think the court obviously has my submissions on the first issue without my needing to labour them further. If I can touch very briefly on the 3 remaining issues, and I do propose to deal with them very briefly. The second issue is the issue of reputation, private and family life. And my submission on that is that if one approaches cases such as this consistent with Ray J, one doesn't get oneself into the difficulties one sees in Sanchez Cardenas against Norway, which is an Article 8 case in Volume 1 at tab 12. This was a case that involved access between the applicant to the European Court of Human Rights and his son, where contact had been granted at first instance, but was withdrawn by an appeal court. And if one looks at the rubric here on page 540, the appeal court said the High Court finds there are many elements that may indicate that abuse, sexual abuse, has occurred. The High Court has nevertheless not found it necessary for its decision to go further into or take a stance on this. And the crux of the court's decision on that complaint is at its paragraph 37 and 38. Perhaps I better just take the court to the assessment on page 550. That the offending passage, it's paragraph 33, indicated that the High Court held a suspicion that the applicant had sexually abused his little boy. And this not only related to the most intimate aspects of the applicant's private life, it also suggested he might have engaged in highly reprehensible conduct vis-à-vis a person to whom he had family ties. It fell within the scope of Article 8. It constituted an interference. It was in accordance with the law. Then over the page, it satisfied the legitimate aims requirement, and this is where it then fell apart. At paragraph 37, the offending passage is set out, and what the court says, it thus appears, without it serving any purpose for the resolution of the case, the High Court took judicial notice of the evidence before it and affirmed on this basis a suspicion of its own that the applicant had committed a serious crime, sexual abuse against one of his own sons. No cogent reasons have come to light as to why the High Court in part dealt with it.
The High Court just denied contact by reference to matters completely different from this particular aspect.
So they say.
It's quite something for the Strasbourg Court to say that when a particular aspect has been raised and considered and found only to be a possibility rather than a fact, it shouldn't even have been mentioned in the judgment, isn't it?
Absolutely, absolutely. But there it is, here is the case. And they've sustained the complaint on the basis of the stigma which thereby attached to the father in relation to both his private life and his family life, because it has potentially damaging effects on his family life and private life. Also, it affected his mental health in this particular case, and that's set out in paragraph 38.
Were those proceedings anonymised? Presumably not.
It doesn't appear to be, no.
No, I mean, the Scottish proceedings would be, wouldn't they?
Yeah, well, presumably they were not anonymised in Norway. And,
was his complaint about the denial of contact, or was his complaint about the stigma?
His complaint appears to be about the stigma.
That's what I thought.
Yes, not about the denial of contact. He's saying, I've been left with this shadow hanging over me without it serving any useful purpose. And what the court says is, if you have that sort of shadow raised, you determine it or you leave it out. Now, of course, what is said by the High Court in this decision is so similar to what Lord Brailsford says in his opinion that in my submission, the same sort of principles apply.
So you're saying Lord Ordinary should not have referred at all to the English 2010 not proceeded with charge?
No, I say that he should have determined it on the basis of the evidence before him.
No, but if he couldn't reach a conclusion on fact in relation to that, he should have omitted it entirely.
Yes, my primary position is that he should have reached a conclusion the fact wasn't there, and therefore...
Isn't there more than a hint of unreality about a judge delivering a judgment in which an issue has been raised without actually referring to the issue?
He needs to have determined it. My primary position...
No, I understand that is your primary position, but if I've understood you correctly, your secondary position is that he should have omitted all reference to it.
Well, if it
And
wasn't
for my
relevant,
part, I find that a very difficult proposition to accept.
That's
How
why
is, how is he to explain what conclusions he's reached unless he refers to the incident?
in these particular circumstances, I don't see how he could have done anything other than mention it, and therefore he had to determine it.
But if he had to mention it, how does Sanchez Cardenas help us?
Sanchez Cardenas simply reinforces my primary submission by saying that the European Court of Human Rights says that the National Court should have disposed of the issue in terms of evidentiary assessment and reasoning. That's the way it applies in my submission in this case. It reinforces my primary submission.
Yes, but if you're correct about your primary submission, Article 8 adds nothing. No.
It's simply that's why I'm dealing with it very briefly at the end.
Of course.
The next chapter heading is one that I'm conscious that Mr. Campbell is going to address in more detail, and I'm going to touch on briefly, principally in relation to the father. And this is in relation to the appellate decision, which is in the appendix. And it starts at page 132. One of the oddities about this decision is that the Lord Ordinary records that I made the in re J submission and then comes to no view on it, unless one counts their analysis, because their analysis at paragraph 29 on manuscript page 143 they say, it would be correct to say the Lord Ordinary adopted a somewhat discursive approach to his assessment of the evidence before him. To some extent, he couched his consideration of factual matters in terms of asking whether the local authority had been justified in holding the concerns expressed. He concluded the concerns about the second respondent's sexual proclivities were justified, but at the same time indicated he was not making a finding in fact as to whether the sexual allegations were true or not. He did not make direct findings as to precisely what the second reclaimer's behaviour had been. He did not attempt to set out expressly his conclusions as on the various provisions of Section 84, far less support these by direct reference to findings in fact, which in my respectful submission makes the second division's decision all the more surprising. They make a reference to safety, and that's in paragraph 39. His reference not only to welfare but to safety indicates he had the issues of serious detriment to the forefront of his mind. Well, not if one takes Lord Drummond-Young as being correct in the Sterling case, but there are more substantial criticisms. I would criticise paragraph 32. He noted it was not suggested the second reclaimer was able to show the necessary parenting requirements, so this is a case in which the Lord Ordinary's discussion of disputed issues must be seen against a background clearly understood by all involved, that even with social work support, the reclaimers would not be able to care for the emotional and social needs of the child and would have considerable difficulty in coping with basic physical care needs. He asks, no, that was not established, it was not assessed, and the second division did not have any evidence. And then if we comes to another bit, 36. In relation to the other concerns, the Lord Ordinary considered the primary source of the respondent's concern arose as a result of the continuing relationship between the reclaimers. In other words, the continuing direct contact. There must mean possibility of direct contact because there was no continuing direct contact of the second reclaimer with the child. He identified three main aspects of this concern. Despite the emphasis on the concerns of the respondents, impossible to avoid the conclusion the matters were also a concern of the Lord Ordinary. We consider it unnecessary and inappropriate to read the decisions in a strict and legalistic way and ignore that patent fact.
So, I'm sorry, I hadn't only noticed that when I read it before. The continuing direct contact of the second reclaimer, that's the father
Yeah.
with the child. There was no continuing direct contact. No. So that's just an error, is it?
It is. It rather reinforces the view that the second division haven't had a particularly close reading of this case. But they don't want to read it in a strict and legalistic way, they say. And they say the concerns were those arising from the charges, that's the accusation, those arising from the allegation.
Oh, I think I know what they mean. if the child was to live with the mother,
Yes,
she would have continuing direct contact with the father.
Yeah.
possibly.
Yes.
That would make sense of it.
I think that must be what it means.
Yes.
But of course, the father has parental responsibilities and rights as much as the mother in this case. So, if one looks at why the Second Division appear to have sustained the Lord Ordinary, they say he's entitled to have regard to concerns, notwithstanding that the facts have not been established, other than the conviction in respect of the telephone call, where there is an established fact, I accept. But of course, one of the reasons that the extra division gave permission to appeal was that what one makes of this is fundamentally dependent on what one makes of the London allegations. Because if the London allegations are not established, this man has never, other than a telephone call, misbehaved himself. He's not violent or not shown to be violent. He's not been shown to have any sexual proclivities which, even in relation to persons of his own age, would cause a problem. He's certainly caused no harm to a child on any view.
Well, just hang on a minute. If you look at the top of page 147,
Yes.
you ask us, based on In Re J, to delete from consideration the first half of paragraph 1,
Yes.
the charges against the second reclaimer of criminal conduct in England. Mm-hmm. But there remains the breach of the bail conditions, the finding about sexual thoughts against an 8-year-old daughter, and the threats.
Yes.
Those are the things that remain.
With the following caveats. The breach of bail was when she came knocking on the door and he let her in.
Yeah, you made that point, but what your complaint really is that the Second Division has upheld an approach that relevant to the decision was the unsubstantiated serious sexual charge.
Indeed, indeed. And that changes the whole approach to this man, because if that is not established, he is viewed in a very different way. Bearing in mind he is learning disabled, he's a Tamil from Sri Lanka, this is not his first language, no harm to a child. How one views this man fundamentally depends on the establishment or non-establishment of that very first matter.
You haven't had time to analyse this particular aspect of Re J, but of course the majority said that if there were facts, you might be able to add a concern into the mix in order to generate the threshold.
I'm very conscious of Lord Reed's decision in that and the other two justices that were with him. And that's why I make this submission, that in any case, there's obviously a factual matrix and it's complicated. But in this particular case, if you don't have the allegation in London made out, you view the man very differently. And my complaint is that this local authority dismissed this man without assessing him. Now, if they'd assessed him, we might not be standing here. But they haven't assessed him. They dismissed him in my submission too soon. They said, we have concerns, we're going to take his child away right at the day of her birth. We don't need to make a formal assessment, and we're going to go off to court for permanency.
There were a number of interlocutory hearings here, I think, weren't there, before the 8 days?
Yes.
Would your junior not have gone up and said, there ought to be an assessment of my client?
Well, there was very early on the joint minute, as I understand it, which said there's been no formal assessment. So the point was drawn to attention. And of course, there was the endeavour to assess via Dr. Wolfson, but all that resulted in was a very short period of contact, which would have been too little to say whether or not this man could parent.
Is there power to, in the course of permanence proceedings, to order the local authority to conduct an assessment?
I've never heard it done. I've never heard it done. These are relatively new legislation. It's only been in since, 28th September 2009. But I've never heard of the court ordering an assessment.
No, I suppose the court could say, well, I'm not going to consider your application until you've done an assessment.
But Junior's pointing out there was no contact. and the man had basically been labelled as somebody who should be kept from
One realises there's no contact, and that was what I was raising. What to me seemed an extraordinary thing, that there was no contact. But equally, when the court gets hold of the matter, can't the court say, you've got to set up an assessment, and obviously that's going to have to include some contact? Can't the court do that?
I haven't seen it done. It may be a message to emerge from this is that the court needs to be a little more proactive.
Whatever else happens in this case, there will be messages. I think that can be clear. Whatever else happens.
To do that.
Yeah. You would have, I assume, quarrelled with what was said in the Inner House in paragraph 37, where it is said that the inference to be taken from the whole of the Lord Ordinary's opinion is that there was evidence relating to each of the three above, which he accepted.
That can't be the case.
That can't be true of the first,
No.
the first part of one, because he deliberately says he's not
Yes.
making any findings.
Yes, and that's the most serious of them all. And I would quarrel with whether he really made a finding in relation to the second, given the very careful terms in which he couched what he said about that. Which
Well, in effect, your argument is that he disavowed making a finding in relation to any of them. That's your submission, isn't it? And for the Inner House to somehow contrive to reach the conclusion that he did make a finding, you say, is impermissible.
It's bricks without straw. And particularly when, whatever it is he did, he thought he was doing authority to adopt as well. So how does one unpick this?
Well, you've made your points, Mrs. Scott. Your time is up.
My time is indeed up. I will simply adhere to my note of argument. If I might mention briefly the final point, which is that a permanence order is an order with a number of components. It's a single order. And for the Inner House to say, well, we can't actually substitute anything in here, means that they're not in a position of themselves to make a permanence order. They've simply struck something out without putting anything in its place. And how do they know that that's in the interests of this child? They didn't have the evidence to deal with it. And my time is up. And
well, can I just ask, what remedy are you precisely seeking?
I'm seeking the remedy that the offending permanence order is recalled in its entirety. And that will, in effect, return this little girl to the children's hearing, where it is to be hoped very much that the local authority will approach her future on the basis of a proper assessment of the capacity of these parents, untrammelled by allegations that can't be made the substance of a threshold test for a permanence order.
I suppose, but what you mean by recall this order, you mean obviously set aside the order.
Yes.
And dismiss the application.
Yes.
The petition.
Yes.
That's I think.
Yes, that's how I was getting at.
Yes.
So we're not simply effectively sending it back to the Court of Session. We would be refusing the petition.
Indeed. The court would.
But we wouldn't. That wouldn't be the only thing we could do. Supposing that we accepted your arguments, we could set aside the order, but return the application, the petition, to the Court of Session.
Then there's nothing
to be dealt
the
with
Court of
properly.
Session could be done with it, because it can't go to another Lord Ordinary. It's unlikely that the Second Division would hear evidence. We're well on in terms of the facts. This was
Why can it not be heard by a different Lord Ordinary?
my friend Mr. Campbell will deal with that. There's a recent authority that says it can't be done. It's MacLeod against Highland Health Board.
But I mean, if the situation is that this Lord Ordinary has not made findings of fact, surely findings of fact must be made at some stage in order to decide.
My submission is this is so bad it has to start again, and in any event it would have to start again on the current facts and on a proper assessment. The local authority should do what they should have done in the first place and bring a proper application if that's what they decide should be done.
Right.
Well, the local authority who brought an application, which is a proper application, they're not to blame for the fact that it may not have been dealt with properly by the court.
My submission is if it had been dealt with properly by the court, the Lord Ordinary would have dismissed it. and that would have put the local authority back to seeking their parenting capacity assessment, which is what they should have done.
Yeah. And and what if we're not satisfied that it would have been dismissed if it had been dealt with properly?
It's difficult to know then quite where the court would take it, because the evidence has been heard. I think my Lord will have to hear Mr. Campbell, because I think he has an answer to this.
Right.
And I will defer gratefully to his submission.
I mean, it's obviously a puzzle to us because not infrequently, if we allow an appeal, we send it back to be a case to be properly dealt with at first instance.
And by a different judge very often.
That won't happen here.
Won't happen. No. Well, Mr. Campbell will explain that.
I'm sure he will.
Which comes as a surprise to us.
Unless I can assist the
It
court
might
further.
happen if we decide that it's going to happen.
Perhaps that's so. We'll see. Thank you very much, Mrs. Scott. Mr. Aitken, Mr. Aitken, do you follow?
Campbell does, my lady.
You've nothing to add?
Nothing to add.
I have nothing to add.
Okay.
It's in the supplementary. My Lady, my Lords, in moving the court to allow the appeal, I adopt firstly my written case on behalf of the appellant MB, and as will be apparent from the written cases, there is common ground and neutral ground as between the appellants, and I'm in a position to adopt a good deal of my learned friend, Mrs. Scott's submissions. She has covered such of the ground on the first issue about the approach to the threshold test that there is nothing that I really wish to add to that beyond pointing the court to the drawing together of a number of principles which this court has enunciated in the series of cases relating to Section 31(2) of the Children Act, which I draw together at paragraph 18 of my written case, and which I submit ought, on the approach which my learned friend and I take to the similarity of approach as between Section 31(2) and Section 84 by C2, that these principles are or ought to be equally applicable in the approach to the threshold test under the 2007 Act, because in my submission, when one looks at them, they are driven by the purpose of the test rather than the form of the test, and so one needn't, in my submission, become enmeshed in an examination of the textual differences. I entirely adopt the submission of my learned friend, seeking to explore not the differences but the similarities in textual structure of the two tests. And if that is sound, as in my submission it is, then the decisions of the Lord Ordinary and the Second Division are unsustainable. My learned friend has taken the court through the Lord Ordinary's opinion in detail, and I don't therefore need to add anything about that issue. If I can deal with so that's the first issue. So far as the second issue, the convention point, I don't advance any argument in relation to that, but I don't demur to the submissions that my learned friend makes. And so far as the third issue, as it's focused in the statement of facts and issues, is concerned about inferential reasoning, I do have submissions to make about that. And these develop what is set out at paragraphs 32 and 33 of the written case on behalf of this appellant. And the submissions which I make in relation to the inferences which the court has been taken to in the decision of in the opinion of the Second Division, and to which I'll return briefly in a moment or two, in my submission simply are impermissible against the background of the absence of finding which the Lord Ordinary made. And this, in my submission, is really a question about the character of judicial decision-making and what, in any case, parties are entitled to expect from a court. And as my learned friend foreshadowed, I take the court to a recent decision of the Inner House in the case of MacLeod's legal representative against Highland Health Board. That has just recently appeared in the law reports, and that is included at tab 2 of the supplementary bundle of authorities. Now, that document exists also as an electronic file, but it has the supplementary authorities have a separate MS page sequence, and it begins at MS page 22 in the supplementary form. Now, MacLeod was a case which addressed a number of issues, and it's not. And it's plain that it was a very different sort of action, but it's also plain that the court was concerned to lay down material of a general nature about decision-making and reason-giving, because at paragraph 91 of the opinion, which is on page 680 of the report, and MS page 55, the extra division, whose opinion was given by Lord Brodie, note in a quote from Lord President Roger in the case of Dingley that parties who come to court are entitled to the decision of a judicial tribunal. Such a decision must be reasoned. An oracular pronouncement will not do. And it's noted that in at MacLeod that was uncontroversial, and the discussion related to what amounted to sufficient reasons. And the court then, in the paragraphs which followed, distilled a number of propositions which, in my submission, are not new, but are rather a gathering together of existing principle and practice. And there are, in my submission, 9. I have set them out in paragraph 25 of my written case, but it's perhaps convenient to look at them in context. They're set out in paragraphs 93, 94, 95 and 96 of the court's opinion in MacLeod. And the first of the propositions, which is set out in 93, is a restatement of the idea articulated by Lord President Roger in Dingley that the whole point of a decision is to, of a judicial decision, is to resolve the issues, and so the issues need to be identified. The second point is that proceedings are adversarial and based on the assumption that it's for parties to put before the court the material by reference to which the issues are to be resolved, and that the opinion should record that material. Thirdly, about halfway down the paragraph, however, with the recording of what was put before the court, as with other aspects of a legal decision, regard must be had to the various audiences which the court is addressing. The primary audience is made up of the parties, but by recording material which has been put before the court, it's providing the parties with reassurance they've been heard. The court has a wider audience, and a number of those are included. Most pertinently in my submission for present purposes, an appellate court, and we see that about 4 or 5 lines from the end of the paragraph. Those in my submission are statements of general application. It's the series of propositions which follow on from it, which are bear most closely on the present appeal in my submission. In paragraph 94, the court identifies that where a decision requires the resolution of disputed issues of fact, an opinion should make clear how these issues have been resolved. That means making findings of fact, whether findings of primary fact or findings of the nature of inferences based on primary facts. And then the court goes on to suggest that there may be a variety of ways of doing it, but the key point is that, as it says in the first sentence of paragraph 95, an opinion should make clear the basis on which facts have been found. Taking up from the bottom line, where findings in fact are uncontentious for one or other of these reasons, that should be explained, which is the 6th point. Where a finding is made in respect of facts that were disputed, and this is the 7th point, the opinion should explain the basis on which that has been done. That will include identifying evidence which is to contrary effect. And then the 8th point, where the explanation is that the acceptance of a witness who was challenged, or the preference of one witness over a number of witnesses, or a number of witnesses over another, or other witnesses, that again must be explained. And then finally, the 9th and final proposition in paragraph 96, an opinion should explain how the law has been applied in evaluating the evidence, for example, in relation to onus of proof, and then applied to the facts. Now, none of those propositions in my respectful submission is radical or new, but it's convenient to have them drawn together, not least because they provide, in my submission, a useful way of approaching what in my submission are the deficiencies, both in the fact-finding of the Lord Ordinary and in its consideration of that by the second division. Because it's plain in my submission that while the second division recognised that there were deficiencies in the Lord Ordinary's opinion, nonetheless it was prepared to draw inferences which in my submission it ought not to have done. So I make a broader submission, which is that if a first instance decision maker has not satisfied the requirements set out in paragraphs 94, 95 and 96, then an appellate court is unlikely to be in a position to draw an inference that the first instance decision maker has correctly applied the law to the facts in the case, and that, in my submission, is what is the error that the second division fell into in this case.
I suppose the proceedings before the Lord Ordinary could have been transcribed.
Yes, that's true, my lord. They could have been.
So if they'd wanted the second division, and if we were to remit it, the second division could have before them all the evidence that was before the Lord Ordinary.
That's correct. But that wasn't, in fact, the position. But it would have been possible for that to have been the position, Lord. Yes.
Yeah.
And it's still possible.
Yeah.
The recording still exists and could be transcribed.
I believe that some of the material may, in fact, have been transcribed.
I see.
I'm not sure how much of it has been transcribed, Lord.
Well,
It certainly has.
no, that's not the question. The question is, can it now be transcribed if required?
I'm advised that all of it has been transcribed, so
Right.
that shortcuts the answer.
So if we took the view that what's happened just won't do, and we send it back to the Inner House could consider the matter for themselves on the basis of all the existing evidence, and they could hear further evidence if further evidence were required.
Well, it's certainly the case that the Inner House, while seized of a case, has the power to remit to one or more of their number to hear further evidence, my lord. I'm coming to the point foreshadowed by my learned friend about the difficulties to which that gives rise, but in principle, of course, your lordship's right.
Mr. Campbell, are we coming back to the point about the inability of the Inner House to direct a rehearing before a different Lord Ordinary?
Yes, I will come back to that.
You will come back, because that's MacLeod, and I just was worried that we had, as it were, put MacLeod aside. But if you're coming back to it, that's fine.
Well, I can, whilst the court still has MacLeod to hand.
Correct me if I'm wrong, from a brief skimming of the case, this was a claim on behalf of a girl who had suffered serious brain damage at birth. The allegation was negligence on the part of the hospital, and the Lord Ordinary, as we would say in England, dismissed the claim.
Yes.
And the daughter, by her parents, appealed, and the Inner House held that there'd been grave deficiencies in the way in which the Lord Ordinary had given his judgment. And then, as Ms. Scott and you have both said, the court finds that there is no ability to remit the matter to be heard by a different Lord Ordinary, as a result of which the daughter's claim, notwithstanding the grave deficiencies, gets completely dismissed. Is that right?
That's correct, my lord. And the court ultimately finds that it was not competent for them to send the matter back to be reheard at paragraph 162, which is on MS page 82. This forms part of a larger section of the opinion beginning at paragraph 153, which is on MS page 77 in the bundle.
The problem seems to be that the successful reclaimers didn't want the Inner House to deal with the case itself.
Yes.
And paragraph 161, Lord Brodie is saying that that's the way these things are dealt with.
Yeah.
Where the Lord Ordinary has been shown to have erred, it is for the Inner House to decide the case.
Yes.
And whatever one thinks of it, the pursuers seem to have been hoisted by their own petard and saying, well, one thing we don't want you to do is to decide this case yourselves.
Yes. And it's not immediately evident from the opinion of the court why that was the line which was taken, but your lordship describes the position so that whatever else may be a possible route, it would appear that sending the matter for further examination by a Lord Ordinary is not competent because that's what the court says.
Because otherwise, I mean, the case is on all fours with Dingley. I mean, Dingley is a case where the Lord Ordinary made a complete hash of a medical negligence case. Lord Roger then meticulously dealt with all the evidence in the inner house and found and reached a decision.
Yes.
But among his errors, the trial judge may not have made the findings which would enable the inner house to do it for itself.
And that is the position which my learned friend and I adopt in this case, that the Lord Ordinary did not make findings which would have allowed the inner house to...
Well, what's the nature of the appeal to the inner house in a case such as this? Is it a rehearing, or is it simply a review of whether the Lord Ordinary has applied the correct legal principles?
It's, in essence, a rehearing, Lord.
So the inner house could have, the second division could have had further evidence?
It would have been competent for that to have been done, Lord, yes.
I mean, normally it would, it isn't hamstrung by the absence of findings of fact by the Lord Ordinary, because it can look at the transcript, it can look at the productions and so forth, and it can make its own findings of fact. There would be more of a problem if the evidence-led had been inadequate. In that situation, there would have to be an application to allow fresh evidence to be admitted, and there are the same sort of tests as in England that apply to whether that application would be granted.
Yes, because the court has the power to proceed in that way, and as your lordship indicates, generally that would require an application to be made. I can't immediately think of a case where the court has suggested on its own. So that I hope addresses the question of the practicality of further evidence. It's simply it's not competent for the matter to be dealt with by a Lord Ordinary. It would have been competent to have been dealt with before the division, but it wasn't.
Yes, and why can't that now be done if this court sends it back to the inner house?
In contrast to the question of it going back to the Lord Ordinary, I can't immediately see an objection of competency to that being done. There might be good practical reasons, but as a matter of competency, my lord, I can't see any objection to that.
Well, I see that we're told that there's an application for permission to appeal in MacLeod.
Well, your lordship has the advantage of me.
No, I have the advantage of a very astute judicial assistant. Just drawn that to my attention.
What I can say, my lord, is that MacLeod was before the second division at the time the reclaiming motion was heard in this case, because I refer to it in submissions, in the division records that in its account of my submission. So that, at least at the moment, is a statement of the law.
But it would appear from paragraph 158 of MacLeod that there is quite a lot of authority for the proposition that a case can't be sent back basically for retrial by the Lord Ordinary.
Yes, and that, my lady, is no doubt why the court was satisfied not only that it would be unprecedented, but that it was incompetent.
Mm-hmm.
Yeah, there are two different things.
Yeah, oh, indeed. Indeed, my lady, yes.
Yeah. Is there any family authority or children authority to the same proposition?
I'm not immediately aware of it. I'm not aware of any, and nor immediately are others on this side of the bar.
Mm-hmm.
So against that background,
Well, I see. I'm sorry to interrupt you, but I see that in paragraph 158, the citation from Scottish ministers against Sturton and Anderson refers to case of T against T, Lord President Roger. And simply from the name of the case, I suspect that that's a family case.
Sounds like it, yes, yes. Yeah.
Apparently, as authority, that it's not normally competent to remit to the Outer House for a rehearing of the proof by a different Lord Ordinary.
I'm grateful to my learned friend, Mrs. Scott, who advises me that she was in that case where the issue was a remit not to the Outer House, but on appeal from the Sheriff, and a remit back to the Sheriff Court.
That could be different, couldn't it?
Yeah.
When he says CF, does he mean CF? Does he mean contrast, or does he mean as in?
I think contrast, given the argument was that it was perhaps going to a different forum. If I can return to the opinion of the second division, my learned friend has pointed the court to many of the key passages in the section of the court's opinion under the heading of analysis, and which my submission is against the background of MacLeod. It is difficult to see how the court could have reached the conclusions which it did, standing the way in which the Lord Ordinary's decision was expressed, and further having regard to the omissions which the court itself identified in paragraph 29 of its opinion on MS page 143, the absence of direct findings about the second reclaimer's behaviour, the absence of an express articulation of his conclusions on the various provisions of section 84, and as the court itself says, far less supporting those by direct reference to findings. In fact, on one view in my submission, one needn't go further than that in challenging the conclusion which is reached in paragraph 37, to which the court has also been taken, and paragraph 37 is on MS page 147, that the Lord Ordinary did not set out in detail the evidence led by the respondent, but the inference to be taken from the whole of the opinion is that there was evidence relating to each of them. That's the matters in dispute. There was evidence relating to each of them which he accepted with respect, Lady my Lords, that won't do where the court is attempting to, the appellate court is attempting to reach a view about whether or not the first instance decision maker has actually applied the legal test correctly, where the appellate court has itself identified an absence of findings by the first instance decision maker. And although the second division does treat in paragraphs 31, 32, 33, 34, 35 and 36, the various evidential issues before the Lord Ordinary, in my submission there's nothing there which amounts to a finding by the second division. And the court, I think, is careful in those paragraphs to identify the limitations of the analysis of the Lord Ordinary. For example, in paragraph 32, about the level of assistance which the appellants would have required. The Lord Ordinary did not make any explicit finding as to the level of assistance he had in mind, but accepted the evidence of Helen Stirling to the effect that even with extensive support, it was likely that the first reclaimer would not manage the task of meeting the child's emotional needs. He noted it was not suggested that the second reclaimer was able to show the necessary parenting required for the care. My learned friend has canvassed the second part of that. In relation to the first, I simply point the court towards the rather more expansive explanation which I give in this appellant's case about that part of the Lord Ordinary's reasoning in paragraph 21. So that taken as a whole in my submission, the second division simply was not entitled to draw the inference which it did in paragraph 37 in reaching the conclusions which it did, nor in my submission was it entitled to conclude, as it did, that there, in paragraph 41, that the findings in relation to the three areas of concern are sufficient to meet the threshold test. Lady, my lords, unless there are any further matters with which I can assist the court, I would otherwise simply proceed to renew the motion I made at the outset.
It appears not. Thank you very much indeed,
I'm
Mr.
obliged.
Campbell. Ms. Cartwright? Is there anything you wish to add? Ms. Dowdles? Would you like some of the furniture
Yes, if I may.
redirected towards you?
Thank you. Thank you. My lady, my lords, is submitted on behalf of the respondent that the decision of the Lord Ordinary, which was upheld by the second division, wasn't wrong and therefore ought not to be interfered with. And it follows that these appeals ought therefore to be refused. It's acknowledged immediately by the respondent, and it has been acknowledged in the respondent's written case, that the Lord Ordinary didn't set out as clearly as he might have done the reasoning by which he reached the decision that he did, nor indeed did he set out as clearly as he might have done in the usual way that would be expected the findings, in fact, upon which he relied in order to reach the decision that he did. Some careful reading of the Lord Ordinary's opinion is required in order to identify the findings that he relied on in reaching his decision. My submission is that the second division on appeal undertook that exercise and concluded that certain inferences could be drawn from the discussion of the evidence in the Lord Ordinary's opinion, and concluded that there were sufficient relevant findings to justify the making of a permanence order. Excuse me. I will make brief submissions in response to the written submissions in the appellant's written cases and some of the oral submissions that have been made in the course of this morning. It's not my intention to make any submissions in relation to the Article 8 point to supplement those that have been made in the respondent's written case. And in the absence of any submissions this morning in relation to the issue of the absence of any provision for contact, it's not my intention to make any submissions in relation to that matter either. All that I intend to address the court on is the nature of the threshold test and the extent to which unproven allegations of criminal conduct may be taken into account. And I will take the court, albeit I'll do that as briefly as I can, since it is set out quite clearly, I think, and quite fully in the respondent's written case, the content of the Lord Ordinary's opinion, which I say is sufficient to justify the decision that he reached and to justify the decision on appeal of the second division upholding the Lord Ordinary's opinion. It was recognised at the outset, and my learned friend Mrs. Scott very fairly made the point in her submissions that the local authority respondent in this case recognised that the Lord Ordinary's opinion could not be sustained insofar as it related to the question of authority to adopt. And it was for that reason that the concession was made before the second division immediately that that aspect of the appeal could not proceed. When I say immediately, I mean in advance of the hearing commencing. So there was recognition, and there remains recognition, that there are problems with the way that the Lord Ordinary has expressed his opinion, and it's plain from the discussion that's taken place this morning that my lady and your lordships have identified those difficulties, which are not difficult to identify. But nonetheless, the respondent seeks the refusal of this appeal, there being, in my submission, sufficient in the Lord Ordinary's opinion to have properly permitted the second division to uphold the decision.
Is it too pedantic to suggest that there's a difference between acceptance of evidence and findings of fact? What the second division seems to do in seeking to ascertain from the Lord Ordinary's judgment a sufficient foundation for the conclusion that they reached is that he accepted certain evidence. It doesn't necessarily follow, or does it, that acceptance of evidence must be equiparated with a finding of fact?
Well, that is, of course, a difficulty with which I have struggled in this case. And the conclusion that I have reached is that on a fair reading of the Lord Ordinary's opinion and his treatment of the evidence, where he says, I accepted evidence, the conclusion might reasonably be reached, or the inference drawn from that he has found that fact, the fact upon which the evidence was given, to be proved.
But he doesn't at any point, does he, explain that, let alone why, he's found that there's a likelihood of serious detriment to the child's welfare.
He doesn't explain that, ladies. Of course, quite correct in saying he doesn't.
And I think it is clear from your submission that you accept, of course, that he must make findings of fact.
Yes.
In order to, it's not enough to recognise that there was concern, or even that there was legitimate concern on the part of the local authority. He must, of his own, well, not of his own initiative, but he must, in his own mind, reach a conclusion on the facts.
Yes, it's not disputed that what is required is in order to meet the threshold test, are findings in fact, and that I cannot dispute that, and one would not dispute that. The difficulty with the Lord Ordinary's opinion is that he doesn't, as one would ordinarily expect to see, say, I have found the following facts proved and set them out. In the Sheriff Court, as I think is foreshadowed in the written case for the second appellant, reference is made ordinarily in the judgments of sheriffs to findings in fact by way of a listing of findings of fact, and that indeed is a requirement in the
Yes,
Sheriff
but
Court. That's not
the
required.
difficulty goes beyond that, does it not, in that not only does he not set out what his findings of fact are, but on occasions he makes statements to the effect that he's not making a finding of fact.
Yes. Yes, he does do that.
That rather compounds the problem that you have to confront.
Yes, indeed. And in particular, in relation to the matter of the 2010 allegations, he very clearly says, I'm not making any finding in relation to that matter. I'll come on to that matter and the significance of that matter in the context of the entirety of the decision that the Lord Ordinary had to make, having regard to the whole of the evidence and those matters upon which he did rely in reaching his conclusion, much of which I have to say is foreshadowed in some detail in the written case for the respondent, and I don't intend this afternoon to take up a great deal of the court's time repeating what is already set out there.
Well, would that be a convenient moment at which to adjourn, and then you can consider what it is you do want to say to us? Thank you. Well, we look forward to hearing from you further at 2:00.